Hello, I'm Eric Apple, Principal and Founder of Eric Apple Law. Welcome to another edition of our Blogpod. Today we're talking about estate planning and Alzheimer's disease. Memories help make us who we are and give our lives meaning. From fondly recollecting childhood events to remembering where we have to be today, memory plays a vital role in every aspect of our lives. It provides us with a sense of self and makes up our continual experience of life. Alzheimer's disease is a type of dementia whereby brain cell connections and the cells themselves degenerate and die, eventually destroying memory and other important mental functions such as thinking and behavior, which helps us perform daily tasks. While everyone should have an estate plan, it's especially important for families living with Alzheimer's disease. After a diagnosis of Alzheimer's, planning often gets pushed aside because of the stress and fear this topic evokes. However, if you and a loved one has recently been diagnosed with Alzheimer's, you can reduce stress by planning ahead. It's painful to think of a future where you may suffer from dementia, but if you don't plan for the possibility, you not only put your estate at risk, you may put your family and your care at risk. Once you reach a point where you're unable to understand your assets, the document's purposes, or remember your family members, you can no longer create or modify an estate plan. Once the dementia has progressed that far, if you have not made a plan, the only option your family has is to file for guardianship. Petitioning the court for guardianship becomes necessary if you have not executed a power of attorney, which grants an agent of your choice the authority to act for you financially, or a healthcare proxy, which provides your appointed agent authority to make medical decisions. It's equally important to have an estate plan in place for yourself when your spouse has Alzheimer's or any other form of dementia. Dementia does not necessarily mean that your spouse will die before you, nor is there a guarantee that you will remain healthy enough to provide for your spouse's care unassisted. While your spouse certainly needs to prepare an estate plan, so do you. When preparing estate planning documents, the person who signs them is required to have the legal capacity to understand the document's consequences. In most cases, someone who has just received a diagnosis of Alzheimer's can understand the meaning and importance of a given document and therefore has the legal capacity to sign it. However, the ability to understand the implications of legal documents may decline as the disease progresses. If you have no estate plan, at the time of your passing, your assets pass under the state's intestacy rules. Also, without a will, there are no protective trusts to shelter assets for your loved ones. The intestacy rules do not take your wishes into consideration, whereas a will allows you to craft a plan that reflects your real desires and make sure your loved ones are protected and provided for. Creating a plan for your future when you are in the early stage of Alzheimer's can be empowering and ensure your wishes are met as you move forward. The sooner you establish your legal plans, the better prepared you and your family will be, allowing you to focus on enjoying your life and time with your loved ones. We can guide you through all the legal ramifications surrounding an Alzheimer's diagnosis, including medical and asset protection planning, advance directives, and guardianship. We understand what you're going through during this difficult time, and we're here to help. Stay tuned for our next blog pod, and in the meantime, if you'd like to find out more about estate planning, please feel free to visit our website at ericapplellaw.com, where you can learn more, give us a call, or drop us a note. Until next time, thank you for joining us here. Please like, subscribe, and share so we can help you and your loved ones become more informed and we can work together to live more powerfully into the future.